And now I'd like to introduce Simon Minks, who is the public prosecutor to the Court of Appeal in The Hague. Mr. Minks has prosecuted quite a number of high-profile cases at the appeals level, and in particular, he had notable success with the conviction of Dutch businessman Mr. Anreit, Van Anreit, for his role in war crimes committed in Iraq, specifically the use of chemical weapons against the Kurds. Welcome, Simon Minks.
Thank you very much. I think I have to use your microphone. So. Okay. Is it okay? Your Excellencies, distinguished guests, after the impressive speech of Dr. Zryan Abdel Yones, it's my turn to share with you my experience in prosecuting a genocide case in a domestic court related to Iraq. But because I'm very limited in time today, I just have 8 minutes, it's not possible to give you a complete overview of the case and all the legal questions, but I will do my very best to show you the main problems and also the opportunities with these kinds of procedures. I will focus on the facts in this case and the concept of genocide. So, who was Mr. Van Anreit? Well, as you know, he was a Dutchman, he was a self-made man, and he lived and worked in several countries, including Iraq, Italy, Singapore, and Switzerland. In 1984, Mr. Van Anreit received a very important call from the president of an Iraqi company, formerly an engineer agency of the Ministry of Oil. And that president of the company asked whether Mr. Van Anreit could supply him with some chemicals, normally products for the oil industry. Van Anreit thought this was his chance to earn a lot of money, and he raised his own company. He started working with a Japanese businessman, and he needed the Japanese businessman to find a supplier in Japan and to arrange the transport to Italy, as what Van Anreit asked him. But when the Japanese business partner asked a potential Japanese supplier of the TMP chemicals delivery, that company hesitated. They made clear that they had to know where the TMP was going, because TMP can be used as a chemical weapon. And he explained the transporter that it would be transported to Trieste, a city in Italy. The Japanese businessman immediately sent a telex to Mr. Van Anreit in which he explained the concern of the supplier and asked for the final destination. But he also gave Mr. Van Anreit a suggestion that he would understand when Mr. Van Anreit would tell, and I quote, a necessary lie. And exactly that is what Mr. Van Anreit did. The Japanese partner told the investigating judge in this case that Mr. Van Anreit had written to him that the chemicals would be transported by ship to Trieste in Italy and from there on to Baghdad in Iraq. And he had asked his business partner to tell no one about the transport to Iraq. And he told him that the chemicals in Iraq would be used for textile and leather products. Mr. Van Anreit used companies according to foreign law, for instance, Swiss law. And in this case, a Swiss notary had exclusive and only access to the bank account. But you will understand it was Mr. Van Anreit who was actually in charge. And Mr. Van Anreit ordered the transport company not to use the name of his companies in their papers, so no one could trace him or his companies. And for the payments, he used a Swiss bank. And this Swiss bank was also used by Saddam Hussein. But more important, Switzerland has as a so-called banker's discretion, what means that the bank will give no one information about their clients. And at the same time, he was doing his business, Saddam Hussein and Ali Hassan al-Majid organized their devastating campaign against the Kurds in the north of Iraq, the so-called Anfal. And in March 1988, Saddam Hussein and Ali Hassan al-Majid decided to bomb Halabja with mustard gas. And you all know the results. It was really terrible. And yes, This time, the world couldn't look away. But even then, the Iraqi government went on bombing on other towns on the Kurds in the north of Iraq and places in Iran as well with chemical weapons. Even when the Iraq-Iran war came to an end in September 1988, and they bombed for several more months later. And what about Mr. van Anraat? Well, he went on with his business during the crimes against the Kurds and the Iranians, even after the bombing of the city Halabja. He lived in Iraq till 2003, and the Iraqi government gave him money, they gave him a house, and they even gave him a new Iraqi name. From then on, he was called the brave seller of materials. He left Iraq in 2003 because of a new war in Iraq and because he was afraid of being arrested, and then he arrived finally in the Netherlands and gave an open interview on the Dutch television about his business. After that broadcast, the prosecution office started an investigation and he was arrested in December the 6th, 2004. What were the charges in this case? Well, first of all, complicity to genocide in several places in the north of Iraq during the years 1986, 1987, and 1988. And secondly, complicity of war crimes of places in Iraq and Iran. Complicity in both charges because the defendant was intentionally the supplier of chemicals intended for the production of chemical weapons, mustard gas and or nerve gases to the Republic of Iraq. And that brings me to the complicated international aspects of doing a case like this. As I told you, he was living in several countries, so we had to collect a lot of evidence from other countries as well. We have to find witnesses, not only witnesses in Iraq or in Iran, but they lived all over the world. And what about the so-called high-profile witnesses, people who were part of the chemical program of Saddam? Do we have to hear them or not? And do we give them immunity when they gave us a statement? It means collecting documents about the use of chemical weapons and the treatment of the people in the north of Iraq. And fortunately, the National Rapporteur of the United Nations Commission on Human Rights, the Dutchman Max van der Stoel, had produced a lot of those documents we could use in this case. But there were some other problems as well. Should we talk in a domestic court about a genocide far away? What are the consequences of these kind of questions? Or should we leave it to the tribunals and the ICC? And what about the time schedule? We have to do these cases within what we call a reasonable time. We have the European law about it. And what, maybe most important, what about the victims? The victims were represented in our court by a very famous Dutch lawyer, Ms. Zegveld, and she represented Kurdish people from Iran and Iraq. And they gave their testimony in the audience of the judges, and that was sometimes painful. Some of the judges went out in tears, others looked away because it was so terrible what they are telling. But at the end, they just gave their statements. They asked for compensation, but according to the limitations of the Dutch law, it was not possible for them. It was not a simple case, as we called it in the Dutch law, to account with. So in the case against Van Anraat, we collected a lot of evidence of what happened in those years in the north of Iraq. And part of the evidence came, as I said before, from the rapporteur, Mr. van der Stoel, who was also heard as a very important witness in this case. Altogether, it brings us from the prosecution office to the conclusion that there has been a genocide on the Kurdish people in the north of Iraq. And we hold the opinion that there is enough conclusive evidence for the important conclusion, but also that Mr. Van Anraat himself, we must not forget about him, but also Mr. Van Anraat himself had knowledge about the actions of the perpetrators in perspective of the genocide. However, the Court of Appeal thought otherwise, and I quote a little bit from their decision. Nevertheless, a final judicial judgment regarding the important as well as internationally significant question whether certain actions by certain persons as mentioned in the charges should be designated as genocide deserves a better motivated judgment which should be based on conclusive evidence than the one on which the court was able to establish its observation. And finally, they found Mr. Vanderbilt guilty of complicity of war crimes in Iran and Iraq and sentenced him for 17 years of imprisonment. When I look back at this case, is this then a case of victory? I would say yes and no. No, because I sincerely regret that the Court of Appeal rejected our view that there has been a genocide. From my own prosecutor's point of view, I don't think that the verdict on this point is very convincing. First of all, my colleagues and I put forward an overwhelming amount of evidence about the genocide, including a radio fragment of Ali Hassan al-Majid, in which he said that every living creature must be destroyed in the area in the north of Iraq, where mainly Kurdish people lived. And secondly, we had the almost unique situation that apart from written material and statements of other witnesses, the Court of Appeal had the opportunity to ask the best informed expert in the field, namely the rapporteur of the United Nations, to ask him more details about the situation when they start to hesitate whether there was enough evidence for genocide, but they didn't, unfortunately. But on the other hand, it is a victory considering the fact that a domestic court exercised jurisdiction in such a case, and last but not least, found him guilty of complicity of war crimes. Thus, the result gives hope to survivors that justice is possible. It's not easy, ladies and gentlemen, it's not easy to prove someone's guilt in a complicated genocide case like this, but it's not impossible. Van Anraat is just one person in a chain of many more people which can count it responsible for the Kurdish tragedy in the north of Iraq. Wherever these perpetrators are, they must be found and brought to justice. There is still a long way to go, and it won't be easy for prosecutors, but especially for the victims and their relatives. But it's not too late. Thank you very much.
Simon, thank you for that very important exposition of the Van Anraat case and the implications of it. Thank you. And now moving on to Professor Michael Bohlander, who is the professor in comparative international criminal law at Durham Law School at Durham University. Now, Professor Bohlander has trained judges, prosecutors, and government officials in international and comparative criminal law, including the Iraq High Tribunal, which tried Saddam Hussein, and his publications are cited in many cases before the International Criminal Court and many other tribunals. Professor Bohlander.
Thank you, Chair. Can you hear me? Yes. Yeah. Ladies and gentlemen, to start with, I'm one of the persons that Dr. Kushner warned you against. I'm a legal specialist. And I've been asked to give you a rundown of the basic elements of the offense of genocide. So I'll try to do that within my allotted time. The chair has told us that we will get a prize for the shortest presentation. I intend to get it. Now, genocide as a phrase was coined, and that's the conventional wisdom, by Raphael Lemkin in 1944 in his work Axis Rule in Europe. And what Lemkin in essence says about genocide is directed against a national group. It's important, a national group as an entity, and the actions involved are directed against individuals, not in their individual capacity, but as members of the national group. Now, that sounds very encompassing, but the definition has actually been narrowed down over time. For example, that was 1944. Along came the Nuremberg trials, 45, 46. Genocide as such, and of course Lemkin was talking about the genocide of the Germans committed against the Jews. Genocide was not a separate count in the charter of the International Military Tribunal at Nuremberg. It appeared as a kind of a subset somewhere in the war crimes count. So as such, it was not a separate count. Now, after the trials in Nuremberg, the UN General Assembly in 1946 established the resolution 96-1, about genocide, where it defined genocide as the denial of the right of existence of entire human groups. And it said, and it's also important here, many instances of such crimes of genocide have occurred when racial, religious, political, and other groups have been destroyed entirely or in part. And it said the punishment of the crime of genocide is a matter of international concern. Finally, and that's where our story takes us as far as the Genocide Convention is concerned, that convention came around in 1948, entered into force in 1951. Article 1, and I almost got a shock that Dr. Yones was going to take my lecture away from me. Article 1 of that convention says contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent or punish. Article 2, as already mentioned, genocide means any of the following acts committed with the intent to destroy in whole or in part a national, ethnical, racial, or religious group. And then we have the different things like killing members, causing serious bodily harm, deliberately inflicting conditions of life calculated to bring about physical destruction, and so forth. You all know that. The important bit here is that it has now been narrowed down to 4 groups. It's not a national group, it's not religious, national, political, or others. It's narrowed down to 4 elements. The convention also said that the persons who commit genocide shall be punished whether they are constitutionally responsible rulers, public officials, or private individuals. So head of state immunity and all of that should not have played a role in the context of a genocide prosecution. The convention also exhorted the states to set up or enact their own legislation on genocide in the national context, and said that these people should be tried before a competent tribunal of the state in the territory of which the act was committed, or by such international tribunal as may have jurisdiction which the contracting parties adopt. And as you all know, it took until 1993 until such a tribunal came about for the former Yugoslavia. So almost 50 years. Article 7 importantly says that genocide shall not be considered a political crime for the purposes of extradition. So in this context, people could not argue the political crime exception to an extradition request. They would have to be extradited. Genocide, the convention, of course, leaves open the idea of signing up to it and making reservations, as in general international law. I will sign this convention, but I make the following reservations. So these provisions don't apply to me. And the International Court of Justice in 1951 had the opportunity to say something about that. And they said, basically, you can make as many reservations as you want, they don't count. Because genocide is a crime under international customary law, and it's not just a crime under international customary law, it's a crime of jus cogens, i.e. of the compulsory part of international customary law. So whatever you reserve, it doesn't really matter as far as the international law side is concerned, not necessarily the side of the prosecution. International criminal tribunals that came about afterwards for Yugoslavia, Rwanda, and others, among them also the Iraqi High Tribunal, which is actually a national Iraqi tribunal, had genocide provisions which were almost verbatim copied on the Genocide Convention. And as you all know, there have been convictions handed down by both the ICTR and the ICTY already for genocide. There have been domestic prosecutions apart from Iraq, for example, in Bosnia-Herzegovina, Brazil, Germany, the Netherlands, as we just heard, and some in Spain, where we don't have a conviction yet. The important bit to remember about the domestic prosecutions is that under the jurisprudence of the International Court of Justice, head of state immunity still bites, which means you cannot prosecute, as, for example, a German court, the head of state of Iraq. It doesn't work because head of state immunity under customary international law is still a bar to prosecution, despite what the Genocide Convention in Article 3 says that these people should be punished regardless of their position. That's as far as domestic prosecutions are concerned. If these people are brought before international tribunals, no such bar exists. But that is one of the major issues when you want to prosecute heads of state from other countries under universal jurisdiction regimes, for example. Now, another major problem is who are these protected groups? We don't actually know. Not all brutal mass crimes that we can have, like political purges, for example, in the former Soviet Union, China, Cambodia, or Latin America, qualify as genocide because they were often politically motivated, not necessarily based on ethnic or racial grounds. The conventional wisdom is that political and economic groups are excluded from the ambit of the convention on the international level. Some countries have included these groups in their national legislation. Cultural genocide, conventional wisdom is not covered. And the question of what these four groups which we have actually mean is more or less still open to question because the convention doesn't provide any kind of guidance on how to interpret these elements. And of course, when you have two lawyers, you have three opinions, and that means when you have two courts, you still don't know where you are. The ICTR, the Rwanda Tribunal, for example, has held that in theory, these four groups could actually be expanded, the definition, to similarly stable groups, in the case of Akayesu. The ICDY, on the other hand, has said, well, no, actually, we think this list is exhaustive, but we don't actually know what they mean. The definition is not clear, so we may be able to put certain groups under one of the four headings, which are not necessarily on the face of it in there. The definition which is being accepted as a kind of subjective, objective one, it looks on the one hand on the intention of the perpetrator. Why are they picking these people for extermination, for persecution? They are picking them because they belong to one of these groups for discriminatory reasons. And on the other hand, the ICTR in Samanza case has said that we also need to look at the question of whether this group is actually relatively stable, of a certain size possibly, and that would be done on a case-by-case basis. And when lawyers say on a case-by-case basis, it means actually we don't know what the general definition of this is. Akayesu actually came right around again to the definition which Lemkin in 1944 had put up, because Akayesu says, that's the judgment from the ICTR, the victim is chosen not because of his individual identity, but rather on account of his membership of a national, ethnical, racial, or religious group. The victim of the act is therefore a member of a group chosen as such, which hence means that the victim of the crime of genocide is the group itself, not only the individual. Now, a lot of what has been said before in the previous session was about the question, this is law, what about the politics? I want to finish my presentation with a citation from the French philosopher Rousseau from 1758 in his work, The State of War, which goes as follows. As for what is called the law of nations, it is clear that without any real sanction, these laws are only illusions that are more tenuous even than the notion of natural law. The latter, at least, addresses itself to the hearts of individuals, whereas decisions based on the law of nations, having no other guarantee than the utility of the one who submits to them, are respected only as long as those decisions confirm one's own self-interest. Based on what we heard this morning about reaction and the continuing reaction and attitude of the international community, one hopes that Rousseau will be proven wrong very soon. Thank you very much.
Thank you very much indeed, Michael, for that discussion of the legal issues in a prosecution for genocide. And now I'm going to move on to Professor Michael Newton. Professor Newton is the Professor of Practice of Law at Vanderbilt University Law School. He co-authored Enemy of the State, the Trial and Execution of Saddam Hussein. He served in the Office of War Crimes Issues at the U.S. Department of State and was senior advisor to the U.S. Ambassador at Large for war crimes issues. Michael.
It's a joy to be here. I would actually take respectful disagreement with something that was said earlier, which is that there's, for me, you know, you have the titles that matter. There's father, there's scholar, there's West Pointer, there's all the titles that come. Friend of Kurds is one of the most important titles for me ever. I have to say, my affiliation, my connection to the Kurds, the Kurds do have more friends than the mountains. My connection to the Kurds literally changed the arc of my personal life and my professional life. Like Tom, I was in the mountains of northern Iraq. We did good things. I did not expect. I expected and, of course, did the complicated legal questions. We drafted the Security Council resolutions. We did rules of engagement. We protected fleeing columns of Kurds. And I learned to love the Peshmerga. who I saw peeling off from columns of women and children dismounted to defend those columns of women and children against Iraqi tanks. And then we were in the mountains, and this is important. This is not just a personal narrative. You know, we talk about the need, to have these trials and these acts recognized as genocide in the world. I subscribe to that fully. I say this in conjunction with my friend and scholar Michael Bohlander. We're the technical legal geeks. It's important to us to talk about the technical details of the trials, and I could spend all day, as could Michael, giving you detailed mens rea connections and all that. I will do a little bit of that in these comments with relevance to those trials. I think that is important for the future of the world and for the future of the Kurds. But there's an even bigger reason. When you go back to Raphael Lemkin, the term genocide was used in open court for the very first time in world history in the Einsatzgruppen case in the aftermath of World War II. It was not a genocide case per se, but Lemkin persisted until the prosecutor, who was a very short man, he had to lean up over the podium, and he used the word genocide in his opening statement for the first time in world history. It was very close to the Connexus. This is before the Genocide Convention was drafted. This is before all the UN work. Here's the point. The reason we have Genocide Convention law, the reason it was incorporated into the Rome Statute of the International Criminal Court, which I helped to draft, was because the world is a much more drab place. If we simply erase all the distinctions, we become one homogeneous mass of humanity. We lose the cultural diversity, we lose the national diversity, we lose the ethnicity, we lose our religious affiliations. Wouldn't that be boring? Every single species of man deserves, and women, and I mean that in the Greek, the homos, to be protected, both as a matter of imperative natural law and as a matter of indomitable human experience. And I say this is what I learned in the mountains, Tom, was that the display of human dignity, the displays of courage, the displays of national resolve, the indomitable will to survive deserves to be protected and must be protected at all times. Folks, that's why we have the Genocide Convention. That's why it's imperative to make sure that the world understands what genocide is all about in technical legal terms, but more importantly, to show them what it looks like when it happens. Because frankly, the tapestry of humanity and the tapestry of that region would be dramatically lessened without the Kurdish influence. And that's why these trials were important. It was because it's a living, breathing, tangible demonstration of why we have this body of law as an existential imperative, and I believe that deeply. I want to share 4 detailed, as much as time permits, lessons from these trials. The first is a little bit technical, but I think very important from the Iraqi perspective and from the Kurdish perspective, and it's this. In my professional capacity, I negotiated the Rome Statute in 1998, and then subsequent to that, negotiated the elements of crimes, the detailed, for the first time in human history, the detailed mens rea and actus reus, acti rei, and all the details of what have to be proven by the prosecutor when you walk into the Dutch court. The question is, what is the international legal standard for proving genocide? That comes from those elements of crimes, adopted by consensus by every state in the world, to include all of the non-state parties in the Rome Statute process. These documents correctly reflect, to a detail, every shred of genocide law in the world, in those elements of crimes document. And here's why that's important. Was because the Iraqis adopted those elements of crimes as the world standard into Iraqi domestic law, part and parcel. These cases are vitally important to study because for the first time in the Arabic-speaking world, you have Arabic judges, Sunni, Shiite, Kurd, all of them, applying the homogeneous body of law, applying exactly the same standards of law as would be applied in the Dutch court or in the German court or in the Rome Statute in The Hague. That's vital to understand. Against that backdrop, you must understand that the cases deserve a great deal of scrutiny in the world because it's a living, breathing, tangible demonstration of what this looks like. Let me give you an example. You saw one very quick slide of the mass graves. I wish I had time. I could show you from the trial, actual trial evidence that we used in the Untold case and in the Halabja case, hundreds of those slides from the mass graves. Why does that matter? Yes, there are victims there. It's important to identify them. But what we do is we're able to prove genocide by corroborating the eyewitness accounts of victims who will testify, we had people taken from our village on or about this date to this mass grave. You go into the mass graves, you find Kurdish clothing, you find Kurdish jewelry, you find a great deal of corroborating evidence. You find prescriptions. Imagine if you're told you have 15 minutes to leave. Moms, what do you tell your kids to take? Their prescriptions, their identification documents, all of which we find in the mass graves. And more poignantly, if there's any mom in the audience and you were told you had to leave right now and you didn't know when you were coming back, I dare say that you would tell your children to take something that reminded them of home. We find children in those mass graves clutching that thing. In some cases a toy, in some cases something from the backyard, in some cases a pet that reminded them of home. I wrote the opening statement in the Untold case, and I handed it to the prosecutor. I said, I'm just the international advisor. This is not my trial, it is your trial. I said, if you're Mike Newton and if you're in The Hague, this is a great opening statement. But you're not Mike Newton, you're not in The Hague, make it your own. What he actually did with that document was he split it into two. So that document became the substance of his opening and the substance of his closing as well. But what he said was poetic. He said, in this courtroom, which was about the size of this room, the angels of the Iraqi Kurdish children fly and watch us as we bring justice to the Kurdish people. And he was right. So the important point about these trials is that it, for the first time in that region, in the Arabic language, brought that homogeneous body of law into practice. The second thing is the distinction Michael made about law and politics. That is from the day one, from the very first moment when Saddam Hussein stood up and he said, I am the president of Iraq, you may not try me. The judge looked at him. In this case, in the first trial, the jail trial, a Kurdish judge looked at him and said, you are a criminal defendant like any other criminal defendant. We will apply the law, we will apply the procedures, and there are regulations for how to do that. And the point was, despite what the rest of the world might have thought or what European capitals thought, that struggle between law and politics was omnipresent every minute of the trial. Point three, why do these trials deserve a great deal of more scrutiny than they've gotten in the outside world? And why is it important in the future that we remember these lessons? The difference and the importance of public information and public misperceptions. It's vital to remember that just like the ICTY, just like the Rome Statute, International Criminal Court, at that point in history, the Iraqi High Tribunal, what became the Iraqi High Criminal Court, was under intense pressure from the people. We did those investigations in almost record time. The jail trial went first because under Iraqi law it was prepared, it was ready to go. It was a simple case. Untold took longer to prepare because it was a dramatically more complicated case. Dramatically more complicated. That's why that was the second case. And then Halabja came later as a standalone case, again, because of technical legal reasons. And here's the point. The watching world audience from the very first day didn't understand, why is this taking so long? Why is this so different? Why is a different set of law and politics being applied? And the court did, in my opinion, not such a great job of explaining why. That's why these cases have to be studied, so that the world understands these things do take time. There is a process. There is law to be applied. And this goes to the perception of the trial. You see, the danger, if these are not studied well, is that there's a lasting perception that says, yes, the Iraqis did Untold. We did Halabja. We did the Faili Kurds case. We did the Merchants case. We had cases with victims from every part of Iraq, every ethnic group, every religious group. And at the end of the day, the perception is, oh, that was all just politics. That was all just revenge. No, the cases have to be studied to demonstrate conclusively, both for law, for legal purposes, for the legal geeks like Michael and I, but also for the public opinion at large, this was about process. It was about law. And lastly, I will tell you without spending time, because I'm out of time, to emphasize that these cases also have great legal significance. We extended the Kurdish analysis in the Untold case in a very pointed way. We extended the Akiyesu analysis in a very concrete way. For legal scholars, this is a minefield. And I promise you that in the jurisprudence of the International Criminal Court, they're missing a great deal of relevant law if they don't refer to these cases from the Kurdish experience. That's all. Thank you.
Thank you very much, Michael, for so forcefully describing the importance of these cases of genocide crimes against the Kurds. Thank you. And now on to Anne Dubitzky, who's the Executive Director of Global Justice Group in the USA. Anne.
Thank you very much, Your Excellencies, distinguished guest. I feel very honored to be here today and to be a participant in this historic and very important conference. And I will also be very brief. As was mentioned, I'm the Executive Director of Global Justice Group. Global Justice Group is a not-for-profit human rights NGO based in the United States. And what I'd like to describe today is a little bit about what our organization is, and more importantly, what we're doing with respect to the Kurdi victims of the genocide in Kurdistan. Global Justice Group was founded 10 years ago on the principle that by holding supporters of terrorism and genocide accountable, we can offer victims of such attacks an opportunity to seek compensation and reclaim their dignity. Our team is dedicated to helping empower victims around the world in their pursuit of recognition and justice. And in this case, we're talking about civil justice as opposed to some of the criminal claims that have been spoken about until now on this panel. I'm here today actually not really representing our NGO, but representing some 1,200 of the many thousands of victims of the Kurdish genocide who seek justice, not revenge. Global Justice Group has opened an office in Erbil, Kurdistan, under the direction of Sami Jalal, who's sitting here today. There, our staff, under Sami's leadership, in cooperation with the Halabja Chemical Victims Society, has begun the task of collecting information about the victims and the families of victims of the Halabja attack. We are documenting injuries of the survivors and in detail documenting also the deaths of those who perished. This is very consistent with some of the things that Ian Hansen spoke about earlier today. So why is it important to document injuries and deaths in such detail now, 25 years later? I think that these records serve several purposes, and I'll highlight three in particular. First, having meticulous documentation of the identity, the injuries, the deaths of victims creates a historical record of the genocide. And this is an important part of the personal healing process for the survivors. In the case of the Kurdish victims of Saddam Hussein, for at least 15 years, as you all know, until Saddam's fall, the thousands of victims and their families were prohibited from even talking about what or who caused their injuries and the deaths of their loved ones. So they suffered in silence. Some were able to seek medical treatment, but without being able to explain that they were victims of chemical weapons, they couldn't always receive the proper treatment. Others avoided seeking treatment at all, knowing that the source of their ailments was unmentionable. Now those who survive are able to speak, but only with a detailed record will their stories, so long untold, be believed by the larger world. And as Peter Galbraith said, that telling the stories is important. Hearing the stories is important. Having the stories documented and recorded in a systematic way is an essential prerequisite to individual healing and to, we hope, preventing the recurrence of these sorts of events. Secondly, we feel that documentation enables societal healing, or at least helps. When the last of the survivors is gone, detailed records and documentation will help assure that the Kurdish genocide and the horror of the chemical attacks cannot be denied by later generations. This, too, is an important part of the larger societal healing process. Without a clear record, it is easier for deniers to make their case. As we see with the Armenian genocide now almost 100 years ago, the absence of documentation opens the door to denial, which also doesn't mean that in the presence of documentation people don't deny genocides, but certainly the absence of a record makes it easier. And that continues to perpetuate a societal wound. Thirdly, documenting the damage and the suffering, the death, is an essential step in seeking justice. And this is where Global Justice Group also is playing a specific role. Justice is another avenue towards healing. It helps the individual move from being a passive victim of an attack to an active participant in the process of seeking redress. Global Justice Group hopes to give a voice to these until now silent victims and help them in their quest for justice. Research has shown that some of the same entities and organizations who enabled and assisted in the unspeakable horror of the Holocaust in Europe during World War II were responsible and involved in producing and supplying the chemicals that form the basis of the chemical weapons and poison gas which were used in an effort to annihilate another minority ethnic group less than 50 years after that. Helping victims of the Kurdish genocide pursue their legal rights, their civil legal rights, in courts of law helps promote civil society. Global Justice Group is working with attorney Gavriel Mairone and other lawyers in the US and in Europe to help to represent victims in Kurdistan in bringing lawsuits on behalf of against the perpetrators or alleged perpetrators of these crimes and the enablers of these crimes. Instead of seeking vengeance, they seek vindication. We're working with them to promote the rule of law. The Halabja victims, through us, are also asking that this message be communicated to the world. The voices of sanity around the world must speak up to prevent the continued production and transportation of chemical weapons. We must be sure that those responsible for producing and supplying and transporting chemical weapons are held accountable and that such weapons are never used again. We also have an educational mission. We want to be sure that governments around the world recognize the Kurdish genocide and the identity of those who enabled it. We would like to see the Kurdish genocide become part of the history curriculum at schools around the world so that the Kurdish victims will not be forgotten, and more importantly for all of us, so that the horror of chemical weapons the horror of chemical weapons will not be seen again, and that this kind of unfathomable tragedy will not be repeated in the 21st century. Fortunately, Global Justice Group is not alone in this quest. We're working with many people around the world. We work alongside other international human rights organizations, the Simon Wiesenthal Foundation among them, and organizations throughout Europe and in the United States advocating the rights of victims and working to prevent future genocides. The Halabja victims, through Global Justice Group, hope that by increasing awareness of their suffering, the world will become a safer place and that relations between and within nations will be improved. On a somewhat lighter note, I just want to cordially invite and personally invite all of you to attend the formal celebration of the opening of the Global Justice Group in Erbil on Thursday, March 14th, 2013. This event has been planned to coincide with the official KRG commemoration of the 10th anniversary of the liberation of Iraq and the 25th anniversary of the Halabja attacks, which will be held in Erbil and Halabja on March 14th through 17th of this year. I do hope that those of you who can will make an effort to join us for these historic events. Again, I want to also thank everyone who supports Global Justice Group. We do not receive any government support. We subsist entirely on private donations, and without the support of our generous donors, we would not be able to pursue our important mission. Thank you all for your attention and support.
And thank you very much indeed for describing your very important work on behalf of victims. Thank you. And now for our final panelist, coming on to Gavriel Mairone, who is the founder and managing partner of Law LLC, an international US-based law firm representing victims of genocide, crimes against humanity, war crimes, torture, terrorism, and human trafficking. Gavriel.
Hi. I'll try to break the pattern and stand up and stretch my legs while I'm speaking, if that's okay with everyone. So, well, I'll start. So as you've heard, I'm a private attorney, and actually my focus is more with the my individual clients. We don't represent governments, and we're not really involved in the large political questions, the global questions that mostly have been raised in this meeting today, but really we deal one by one with all of our clients. And the idea is to represent them and fight for their own individual justice. Now you might say, what's individual justice? Because mostly our friends here, and Simon Minks, for instance, a very brave warrior, and others have brought a certain kind of justice, which is the normal way we think about justice in the Western world. And that is when there's a crime, we find the perpetrators and we punish them. And that's considered justice. But there's some horrible crimes that have such a destructive effect that it goes beyond any kind of a simple crime. And so punishing the perpetrators still leaves families and individuals totally destitute. And I'm going to go into that in a little bit of detail. And so their individual justice, while they maybe have some kind of satisfaction that someone was punished for what was done to them or their families, they're still usually left destitute and victims with the psychological feeling of being helpless and being abused and have no response. Now, you see the topic of my lecture is ending impunity for the profiteers and enablers of genocide, crimes against humanity. What does it mean, impunity? Who has impunity? Impunity, as you're going to see, is those people who get away with a crime and no one ever pursues them for any reason. I was just reading Graham Greene book the other day, and I found a quote that seems so apropos. Your old-fashioned murderer, killed from fear, from hate, or even from love, Mr. Rowe, very seldom for substantial profit. None of these reasons is quite respectable. But to murder for position, that's different. Because when you've gained the position, nobody has a right to criticize the means. Nobody will refuse to meet you if your position's high enough. So who are these people that have such position that can foster these crimes, can finance them, can profit from them, can induce them, and then no one can question them? Well, we're going to find out the answer, but first we go to Edmund Burke, who said, the only thing necessary for the triumph of evil is for good men to do nothing. And this is what we're here about today. First, let me introduce to you one of my clients. And unfortunately, her story is not unique. And as you've heard from some of the other testimonies, if you multiply her story by 180,000, you'll get an idea of the scope of what's happened here. Suhiba was a young woman, a mother with 7 children, was pregnant, living in Halabja on the morning of the attack, March 16th, 1988. The first wave of bombers came over the city, and they bombed the city with high explosives. The day before that, or 2 days before that, there was battles going on in the area, and the people living in the villages were accustomed to hearing bombing and the noise of such explosions, and the immediate response was to go down into the basements of their homes. The reason that Halabja was bombed with high explosives first was to break all the windows. Now, why did they care about breaking the windows? Because the next wave was the poison gas. And with the windows broken, the poison gas then could seep down into the basements and reach its victims. So during the day, wave after wave of planes came and attacked the town, street by street, section by section. But these bombs had only a small amount of explosive in them. They were not the high-quality explosives of the original bombs. So for the people in the basements, it sounded like this attack was outside the city, far away. It was like a distant thunder rolling across. So they felt relatively that they were secure, that they were not in danger. But the gas was spreading across the city and seeping into the buildings. Sometime in the afternoon, a neighbor came into their house and said, "We must leave right now. They're using gas on the city." So Sahiba took her 1.5-year-old baby, strapped her onto herself. Her young son gave to her oldest daughter, and with all of her children and her husband, they left the house. She said, immediately going out the door, there was hundreds of bodies strewn all over the place. They started walking through the town, And she said she began to feel it's hard to breathe. And she began to feel pain. Her oldest daughter said to her, "Mommy, I'm finished. Take the baby." And she handed Sahiba the young child that she was carrying. Right after that, another one of her children fell down and died. Sahiba saw on the ground two people, parents, lying dead, and a little girl crying on their bodies. She turned to the little girl and said, "What's wrong? Why are you crying?" And at that moment, Sahiba's eyes started to burn, and her throat started to burn, and she lost her sight, and she fell on the ground herself. A third boy fell on top of her, and he died gasping for breath between her legs. Somehow her husband and her two boys, who were aged 11 and 8, fled and disappeared somehow in the fleeing. And she was left on the ground, couldn't move, couldn't breathe, burning pain in her eyes, baby strapped onto her, 1.5 years old, and she passed out. The next day, Iranian troops apparently came into the town, and they came into town with medical supplies. They found Sahiba laying there, and they said to her, and she was still alive, and they said, come, Aunt, we're going to take you out. And she said, "Where's my baby?" She couldn't see. And they said, "No, forget about her, she's finished." And they said, No, I'm not leaving without my child. And they said, No, she's finished. No, she insisted. So they took the baby with them, and they brought her across the border to a refugee camp, into some kind of hospital, field hospital tent, where she was separated, all alone, for several days, not knowing where her baby was, not knowing where any children were. In fact, she became confused, and she didn't even know if any of her children were alive or dead. She couldn't think clearly. But she was worried sick about where her family is. So being blind, being in pain, she left the field hospital and began to search this huge refugee camp for her children. Imagine. She did find them. She found her 2 sons, and she found her 1.5-year-old baby. Each one was of a different family. No one knew that anybody else had survived, and her husband survived. And when she found her 1.5-year-old, the baby started crying and refused to accept that this was her mother, because she was burned in her face, and she looked so different. And the baby refused for 1 month to even accept that this was her mother. And finally she did. Sahiba said to me that she left her husband because she could no longer function as his wife. And so she was now alone with the 3 children. She made a decision to return to Iraq by herself, blind, with the kids. And she did. And what happened when she got to the border? The Iraqi troops arrested her, and they threw her and her 3 children into jail. And there she sat, no medical attention, in horrible pain, deteriorating health condition, blind, 3 children with her. And one of the guards eventually took pity on her, and he said, come, mother, I'll take you for some help. What do you need? She says, I need some kind of medication. For my eyes, they're killing me. So he said, come, I take you to the hospital. He takes her to a hospital, and they said, where are you from? She says, Halabja. They said, we're not allowed to treat you. And they threw her out. So the guard took her to a clinic that was for soldiers and police. Took her to that clinic. They didn't throw her out. They immediately called the Secret Service, and they arrested her. Without medical treatment, they threw her into a different jail. So now she's in one jail. Her baby and 2 sons are alone in another jail. And that situation lasted for a month or more. And then finally the war ended, and all the prisoners were released. She comes out of jail. Now she's blind, and she's got to try to find, when she does, find her children. And somehow she raised her children. The last time I met with Sahiba, I took a very famous journalist, John Ware, BBC Panorama presenter, with me. And John asked her the following question. She said, I understand we're working on trying to bring a legal case. If a legal case is brought and we win the legal case, what are you looking for from these companies that supplied the chemicals and enabled this to happen to you? And she said the following. She said, I'm 53 years old. I lost 4 children. I lost my eyes. I lost my lungs. Every part of my body has medical problems. My health is deteriorating. my husband alive but separated because I could not fulfill my wife's duties. There is no way for me to regain my health, cure my children who are suffering to this day psychologically, or return to my life. All I wish for today is justice. So how can we help Sahiba reach justice? It's the wrong question. The question needs to be, how can we enable Sahiba and every one of my clients and these victims for themselves to fight for justice? Why? Because they need to stop being victims and to be survivors. And they need to regain the dignity that was stripped from them from being helpless victims. But let's not underestimate, this battle is almost impossible. As Simon Minks can tell you, it's so complicated to bring a case like this, and it's so long after, and it takes so much effort and so much evidence to develop. And believe it or not, the laws generally do not favor us. But without justice, as Ann Dubitzky said, how can we heal? So who are the participants in the commission of this crime? Well, we know them. We know Saddam. We know Ali Hassan al-Majid. We know the soldiers were perpetrators and the pilots in the planes. But my focus is on 4 and 5. The enablers, the one who provided the weapons, provided the chemicals, and the profiteers, the ones who built the factories and made a profit. Did these people know what they were doing? Well, if they didn't know what they were doing, of course, then probably they have no liability. But if they did know what they were doing, then they're participants. And this is the job to prove that they knew that they weren't building some pesticides, they were actually building death on a massive scale. And if we don't stop this business of selling death for profit, and how many businesses, by the way, to this day, 25 years later, how many of these businesses have lost their profits that they gained building all this stuff, building the largest chemical weapons factories in the world during the Cold War in Iraq? How many? Anybody know? None. Not one. Millions and millions and tens of millions of dollars, marks, pounds in profits, and no one's been held to account for it. But if we don't stop this, well, look, where's the next one? How did a regime like Syria have so many chemical weapons that now we're talking about it? And maybe the reason we're talking about it now is that if these, now with all the non-state actors, if these chemical weapons go onto the black market, like what happened in Libya, we'll find those kind of pictures not only in Halabja, some town that no one heard of in the West, but we'll find them in New York and in London and Paris and so on. So we have to, so my job is to be this kind of sword, actually. I'm just a rusty old sword. But in the hands of a fighter like Sahiba and my other clients, with their courage, and you can't imagine how much courage and will Sahiba and others like her, then this sword, this steel is unbendable. And this blade, with all my strength, will not yield. So we need to prove the knowledge of this shocking disregard for human life that these companies made profits on. So we searched the whole world, and we've been working for 2.5 years on this project. And we've gotten all kinds of documents from the CIA, from the US Department of State, from German government, Senate hearings, some of which have talked. And you want to know something? What's really weird? One of the explanations of why no one knew that they were building chemical weapons is they said, well, we thought we were building pesticides. Okay, all right. So they built these big factories, and they built a gas chamber for dogs to test it. So pesticides and killing mammals and primates to test the toxicity and lethality of it doesn't add up. These people definitely knew what it is, and it's our job as lawyers to somehow get this case in court and bring justice. And with the help of people like Global Justice, who have spent thousands of hours, and we have spent thousands of hours in research, but they have in the field spent really thousands of hours compiling a massive amount of files to document every person. Because we're not dealing, my firm, we don't deal in numbers. We deal in each person. Each file has the picture of the people, has their birth certificate, their death certificate, medical records, to construct a life, because we don't have 5,000 people killed in Halabja or thousands more in the other villages. We actually have people. And those are what's left of their files. That picture, of course, is from Raiders of the Lost Ark. But it gives you some kind of an idea how massive this project is and how much effort it takes. But without this effort, as Mr. Minks can tell you, we don't stand a chance. Am I right? These are my clients. This is what happened to their life. But let's not be misled. This fight is not easy. Most of the points in this fight are actually weighed against us. Too much time has passed. There are immunity questions. There's jurisdictional questions. How do you prove that someone knew something when they say, gee, I didn't know, I couldn't figure it out, I didn't know? We have to, the overwhelming, how do we prove when most of the people are gone, how do we prove that they actually lived, that they earned, that they had some kind of life, that they were really human beings? So this is what we have to, and we cannot let these people down. We cannot let my clients down. So I'm here to tell you that the countdown has already begun. We've been working for about 2.5 years. We've collected a massive amount of documents. There's still more, of course, we can get, but the train's left the station, and within the next weeks, the first wave of lawsuits will be launched. So, and the support for all those lawsuits will come from the public, from the media, from you all. Because the one thing that we have really in our side is justice. Because there's no question what happened, and there's no question how horrible it is, and there's no question that if we don't end impunity, then we'll find these problems in all of our backyards. So thank you all very much.